Good day, Crime Talk aficionados. This is Crime Talk, and my name is Scott Reich, coming to you with some breaking news and to actually explain what happened in the Barry Morphew case. Now, if you may recall, as recently as yesterday's show, which I think is well worth watching, is that I said the Barry Morphew case was set for a trial readiness conference today, April 19th of 2022, for the trial to commence, I think it was May 3rd, okay? And I said this is significant because a couple of things are going to happen. Everybody has to announce ready, and I said, or do you think maybe the prosecution won't be able to go forward because their case has been gutted due to their inaction, action? One could maybe describe it as bad faith, potentially, which resulted in the court gutting their case because they failed to comply with the court's order with turning over discovery. And I said there was also the possibility that maybe the defense could potentially have to continue if they weren't able to get all their out-of-state witnesses served appropriately. But then today, as I stated, the hearing was set for 9 a.m. on April 19th, 2022 at 8:51 a.m., 9 minutes before the hearing was to begin, where everyone was supposed to announce ready, where the district attorney, the elected district attorney, Linda Stanley, should have been able to get up and say, Your Honor, the prosecution is prepared to proceed. We are announcing ready. And the defense probably would have said, we're announcing ready as well. But what did Linda Stanley do? She filed a motion to dismiss without prejudice, which really doesn't exist in the criminal arena, okay? With prejudice, without prejudice, it is a term in the civil arena that basically says when you dismiss with prejudice, it means that you are never going to refile, okay? Without prejudice means that you could potentially refile if you get more information, but it has to be done within the statute of limitations. Somehow it has crept into the criminal world a little bit, but the term doesn't really exist, okay? So what does this mean? Okay, normally when the prosecutor dismisses a case, they simply stand up and say, Your Honor, we're moving to dismiss this case because we do not believe that we can meet our burden of proof beyond a reasonable doubt. And that's it, okay? Now, I have mentioned a couple of times, I had a case very, very similar to this, where on the eve of trial, the prosecution moved to dismiss and said, Judge, I object, let's go forward. But they didn't have a witness, and the judge basically granted the motion to dismiss over my objection because I wanted jeopardy to attach. Remember, jeopardy attaches once you seat the jury, when they're all sworn in, ready to go, okay? And the judge in that particular case said the people had better, if they refile this case, better have something more than just, a witness issue, okay? Have to have some new evidence, because otherwise it looks like it's bad faith. It looks like they were not prepared to proceed. Well, their little motion today, pretty much kind of the same thing, okay? Like I said, normally a district attorney will get up and say, we can't prove our case beyond a reasonable doubt. It took 10 pages for the DA to try to explain why they're dismissing this case. So let's just go through their motion somewhat quickly. Here they give a little background. Obviously, on May 6th of 2021, the defendant, Barry Morphew, was brought before this court on the charges including first-degree murder regarding his wife, Suzanne Morphew. To date, Ms. Morphew's remains have not been found, which is always kind of a problem, right? We've talked about this. It's always kind of a problem when you don't have a body, okay? And you'll see that it sounds like everybody realizes that is an issue. In fact, if you jump to the last page of the motion, page 10, under victims' rights, it states, the people spoke with Melinda Mormon Baumunk, the victim's sister and primary representative of the Mormon family. The Mormon Baumunk relayed her agreement with the motion to dismiss and expressed her wishes that we ultimately resolve absolutely whether or not her sister is dead prior to further prosecution. Well, what does that mean? That means even the victim's families maybe has some doubt that it's maybe not a homicide case. I mean, I think that's a reasonable reading of that they expressed her wishes that we ultimately resolve absolutely whether or not her sister is dead. Reasonable doubt there, ladies and gentlemen. And the prosecution knew they couldn't do this case. And everybody who knew a single iota of criminal law knew that this was a weak case from the beginning. It was run, the prosecution was amateur at best when it came to prosecuting this case. They probably committed the equivalent of, if you could as a prosecutor, commit legal malpractice by failing to miss the court's deadlines imposed by the judge's case management order, and then having the audacity to go tell the judge, your orders mean nothing to me. We're just going to follow what Rule 16 complies with. Are you kidding me? Anyway, the prosecution's motions continue. And it says basically the same day the defense entered a formal not guilty and agreed to toll speedy trial to accommodate a trial date slated to begin May 3rd. In subsequent filings, the court added an extra few days of trial in anticipation of more extensive jury selection period. That trial is scheduled to begin April 28th because of the jury selection. Throughout the pendency of the case, the people in law enforcement have been unrelenting in our search for Miss Morphew. For some time, a single location has been the target of an ongoing investigation. For reasons expressed below, the people have a good faith reason to believe further investigation into this matter is essential to answering the most consequential question presented by this case. As this search cannot be accomplished in the coming weeks due to weather and snowpack conditions, the people respectfully ask the court to dismiss the current indictment against the defendant without prejudice. And then they go through the authority which they say that they can dismiss this case, and it is without the court's consent and approval. They cite Rule 48. The authority was regarding dismissal of the case is Rule 48 of the Rules of Criminal Procedure. It says, by the state, no criminal case pending in any court shall be dismissed or no pros therein entered by a prosecuting attorney or his deputy unless upon a motion in open court and with the court's consent and approval. Such a motion shall be supported or accompanied by a written statement concisely stating the reasons for the action. The statement shall be filed with the record of the particular case and be open to public inspection. Such a dismissal may not be filed during the trial without the defendant's consent. The statute parallels that of the federal rules of criminal procedure. And obviously the dismissal mid-trial, I've only ever had that happen once, and it was a very serious matter. But they realized after cross-examination of their complaining witness that her story made no sense. And okay, we'll jeopardy had attached, so we were okay with that. And that's clearly what to do. I mean, for something as big as this, nobody seems to know exactly if the court granted the motion to dismiss yet, and whether the defense objected. I mean, I'm assuming the defense would object and say, no, we want a trial, and that this is done and being done in bad faith, because that is the issue that the court has to determine. But it all goes back to the fact that there was not remains, right? Yes, you can do a no body case in a homicide case, but it usually helps, like in the Patrick Frazee matter, where you had Crystal Lee Kenny saying, yeah, I was there. You're not going to find a body because we destroyed it. They didn't have that in this particular case. Here you had the lead investigator say this case wasn't ready, but Linda Stanley wanted to go forward. Maybe it's because she was newly elected district attorney. But, I mean, for her first homicide, first big case as the district attorney, she screwed this one up royally. And So the prosecution in their motion goes on for several pages, basically trying to justify saying we can do this, and judge, there's nothing you can do to prevent it, which is not necessarily the case. They keep going on saying that this is basically their decision. And page 5 of their motion says the court held in the decision that they were discussing above, the discretion to dismiss lies with the prosecution, not the trial court. Therefore, the question is not whether there might be good reason to deny the prosecution's motion to dismiss, as the respondent suggests. Rather, the question is whether the prosecution sought to dismiss the charges based on a good faith exercise of its discretion. Okay? The prosecution, this case was never ready to go to trial. They knew it because of their own actions or inactions by failing to comply with the court's order. Their case was gutted. Now they don't want to go to trial because they would actually lose. Okay, I think it's pretty fair to say they're actually going to lose. And so now they're trying to save face by saying, well, we got a good faith reason for it. We believe that we have this information that a body is buried in a particular location, but we just can't get there, right? Well, this case has been going on since May of 2021. What'd you do all last summer before it snowed? I mean, why now? I think I would be, just color me skeptical here. Color me skeptical. I think if I was the defense in this case, I'd say, fine, let me see what you have. Let me see what you have. When did the court should inquire, and the defense certainly should inquire, well, if you've been searching this location, when did it become known to you, and why do you think that it's a good faith basis? Did it just happen to fall into your lap within the last week or two after the court gutted your case? Or is there something that you just haven't been able to find? That's going to be the question. Good faith basis to dismiss. And the government's argument is simply that they're saying that law enforcement believe that they're close in discovering the victim's body, that people were hopeful for the search and the discovery of the victim's body would be concluded well before trial. But weather has complicated the effort. Specifically, law enforcement has been focused on is a remote and mountainous region near the Morphew residence. This area received a significant amount of snow over the winter months before a search can be completed. To date, the area has 5 feet of snow, concealing the location where the people believe Miss Morphew is located. As a result, the people cannot safely excavate this area and resolve this unanswered question. By filing this motion, the people complied with Rule 48, a motion to dismiss submitted in writing, publicly available, proffered in open court, and accompanied by a statement summarizing the reasons given. Given the timing of the motion before the trial, the defense does not need to consent and does not have standing to object. The court need only resolve the question of whether or not this motion was filed in good faith, such that a clear and convincing reason exists with which furthers the interest of justice for the public and the defendant. Issues related to speedy trial and other outstanding litigation would not be relevant to the court's determination in this juncture. Oh, you just happen to do it when speedy trial is getting ready to run? Listen, normally you have to kind of take an officer of the court with good faith. But everything related to Linda Stanley's office has been completely screwed up on this case since day one. From the date that she went out there making public statements, the day that she started going out there onto podcasts and talking about this case, and the complete incompetence and ineptitude that their office has demonstrated throughout these proceedings. Remember when everyone always gets upset with me? You think the bad guy is going to walk? Don't blame the defense. You got one person that you can blame, and it's the person with her name at the top of the pleading today, Linda Stanley. That's the person you blame in this particular case if you think that this is not a the result that you were looking for, hope for, that you think is basically justice. It is a situation where the prosecution has completely bungled this case from the beginning. And now when they say, Judge, trust us, good faith, we think we're coming back, it is a situation where I think you must take them with a grain of salt as to what they say, particularly as it relates to the candor before the court, because I think they clearly have demonstrated the fact that, well, they can't be trusted. Their word is not, well, they can't be trusted. Remember, they told the court they were going to comply. They didn't comply. The court gave them other chances to comply with the court's orders. They didn't comply. And what did that mean? It means that, well, they got their case gutted through not the defense's fault, not the defense's fault. Seriously, okay? This is on Linda Stanley and her office. And let me see if I can pull something up because I can't see any of the comments here. Do we even have any comments coming in?
Yeah. Mm-hmm.
Okay, let me pull this up here. Sorry about that. Let's take a look here and see. So, we'll see if we can. There's some questions that we have here, but and the other thing is, and I'm sure the attorneys are loving this so that they can get paid, but if the court grants this motion to dismiss, his bond is released. His bond is released. He gets his $500,000 back, which is there obviously to assure his appearance, and then he can go wherever he would like to go because there are no cases pending. I guess he still has a couple of the minor cases, the misdemeanor stuff for the voter issue, and so that's where I guess he'll still have to stick around, but. Let's see, cement shoes. I just joined. Morphew is not being tried due to the state. Yeah, they blew it. They're dismissing the case because they know they have no case. Okay? And if you go back and you watch our previous videos about Barry Morphew and the 123-page affidavit, and you're just like, wow, when even the court's saying none of this stuff is admissible, and when we got it, we're like, please tell me there's something more. I just thought it was weak case. The preliminary hearing in that case showed, basically that the case was weak. And then it turns out that the prosecution hadn't turned over all of the exculpatory information and kept the exculpatory information from being put in the probable cause for affidavit. Really? You write a 123-page affidavit, but you can't put in there there's exculpatory evidence? That shows bad faith as well. This, like I said, I've always said this. If you don't think that justice has been served and the defendant walks or gets off, don't blame the defense. Look at the prosecution. And this is Exhibit A. This will go down in history as one of the most bungled, worst prosecutions ever done. If not in at least the state of Colorado, it is going to be one of the worst prosecuted cases in the United States. And no disrespect to, our friends in smaller jurisdictions, but when they get a big case like this, and it is so data driven in the sense that there's so much data that they've they've compiled, they have to review, they have to turn over to the defense. They simply don't have the resources to do this type of thing. They have small offices where this type of case could take, designated people. It'd be their full-time job. And now the prosecution comes up with their good faith argument as to why is that, well, we've been trying to find the body. You know what? I think that's the kind of thing where I would be all about, let's have a hearing. When did you find out about this? When did you think this location existed? What evidence? What good faith basis do you have that this evidence, that you believe that you're going to find the remains of Suzanne Morphew at this particular location? I wouldn't just concede to this dismissal because, you can wait. If they do get new information and they charge it, down the road, you can make the argument. But I think you have to say it's in bad faith. And I think the court needs to make some specific findings on this so that, this is somebody's life that, when the prosecution and the government, okay, make a charging decisions, they have such an awesome responsibility. Not only is the duty of the public to make sure that justice is served, but they also have a duty to make sure they have enough evidence to prove their case. Remember, we've talked about this before. The district attorney has an ethical obligation when they file that case that they are saying, I can ethically prove this case beyond a reasonable doubt, that we have enough evidence, we have the right individual that we are charging as the defendant, and we are ready to go within the 6-month statute of speedy trial, 6-month speedy trial requirements of 6 months. That's what they're saying. And does anybody really think that they were ready to go? Of course not. Of course not. They blew it. This case wasn't ready to go. They were never prepared to go. They were trying to prepare their case on the fly, hoping that the defense was going to move for a continuance so they could get their ducks in a row, and they blew it. They blew it. They blew it. And, we give everybody the presumption of innocence in this particular case. But if the district attorney thought they had this case, they should have filed it when they had enough evidence. But when your own lead investigator tells you this case isn't ready to file, and Linda Stanley basically removes him from handling the case, goes to his supervisors and removes him from the case because it's not what she wanted to hear, because she wanted to prosecute this case because she's coming in as a new DA and was going to show people how tough she was and get justice. Okay, what justice has she got for anybody? In her own statement, it sounds like, in her own statement, page 10 of the document, so nobody says the people spoke with Melinda Mormon Bob Monk, and I'm sure I'm mispronouncing that name, the victim's sister and primary representative for the Mormon family. Ms. Mormon, Ma Monk, relayed her agreement with the motion to dismiss, expressed her wishes that we ultimately resolve absolutely whether or not her sister is dead prior to prosecution. Ladies and gentlemen, remember, people got all fired up with me. The defense made the argument, this isn't a homicide case, this is a missing persons case. Well, apparently the victim's sister believes it's a missing persons case as well, maybe a homicide. That's reasonable doubt. Of course the prosecution didn't want this case to go to trial. They bungled it. They blew it. Bottom line is, I would like Angela H. Oh my God, Scott, you called it from the beginning. This is good news. Hope they find the real culprit. And I don't know, like I said, we give everyone the presumption of innocence, right? I think of another bungled case in Colorado. Let's see here. Linda Stanley would be applying a job at McDonald's. Scott, what happens if her body shows up afterwards? It's clear he did it. Well, it depends on what the judge ultimately does. Does he say, no, I'm not going to take your dismissal, basically, not going to grant the dismissal? Like I said, I've never seen a motion to dismiss, even on a homicide case, that takes 10 pages to try to explain why, judge, that, yes, we've had some candor issues before the court, but trust us on this one. There's no bad faith. It's not that we were going to do it. Like I said, I told you in yesterday's program, this pretrial readiness conference was significant because that's where everybody has to announce ready. That's where the jury commissioner is going to say, all right, we're bringing in the jury. We're going to be inconveniencing a lot of people. Are we going forward? And I even said, gee, do you think the people will file a motion to dismiss? Or do you think maybe the defense isn't ready? Are they going to, I said I don't think the defense should, they should be ready to go regardless of whether they have all their witnesses lined up, because I don't think they're going to be able to prove their case. And bam. Sally Vella, you can't blame the prosecutors. Start on the ground with the police officers trampling over all the evidence that was there. Well, I agree. There was definitely some evidence handling issues, but guess what? This ultimately lies with Linda Stanley. She's the one that charged it. She's the one that was going to take all the glory at the press conference regarding the arrest of Barry Morphew. She's the one that's responsible. Her name's on the top of the letterhead. She's the elected DA. She was involved in this case. How many DAs does she have that worked on this case? They got off of this case? Do you think they said, wow, this is a great case. This is going to really help my career? No, they started looking at it and saying, I don't want to be associated with this case. I'm quitting. I'm leaving. Now, we don't know if it's all because of this particular case, but let's face it, this case was going to be followed by a lot of people everywhere around the country. And, it could have been a good thing for them. But they're like, yeah, no, I'm out. Get me out of here. Okay. So like I said, it was so obvious I think so many people, and I know a lot of people are going to be disappointed by this, but like I said, Barry Morphew is presumed innocent. His attorneys were doing their job, and then the prosecution is the one that filed their motion to dismiss 9 minutes before the court proceeding. As Star Love said, they wasted everybody's time and money. Yes, the prosecution did. And just think, Barry Morphew has a civil case pending against a lot of the officers, the lead detectives, Linda Stanley individually, because basically, let's face it, the allegation is that he had his constitutional rights violated by basically being accused of something that he says he did not do and that there wasn't evidence sufficient to go forward on. Do you think this motion may come up at some point in that civil litigation? Yeah, I think so. And he's got damages. All those attorney's fees are damages. That's right. The people of not Fremont County, but up there in Salida. What county is Salida? I don't have my little map. Chaffee. That's right. Chaffee, depending on what part of the state you're in. They're probably going to wind up, and that's going to be the insult to injury, right? If the fine residents of Chaffee County have to write a check to Barry Morphew because of the incompetence of their elected officials up there. Yeah, just saying. All right, let's take a couple of questions here. Those kind of, let's see here. Candy corn on a super chat. Scott, off topic. What does murder with malice mean, and could you get the death penalty for it? Well, not here in Colorado, but basically malice is basically after deliberation in most jurisdictions. Basically with evil heart. Sally Vella says, I saw police letting neighbors in and looking at what happened before the second police car showed up. It's the police who messed this case up from the beginning. Let's see, YouTube monitors. Why is there no body? Remember the lightning strike and the fire department went to the place. Susan Morphew's remains were burnt to ashes. Who knows? But that's the prosecution's burden to show, right? It's the prosecution's burden to prove that she is in fact deceased. Usually there's a body, right? Not we think there's no body. We're pretty sure there's no body. We think it may be buried in the mountains somewhere. We haven't been able to find it. But how many places have they dug up? Remember, they were excavating early on because they were certain they were going to find the remains. And I was literally like waiting in anticipation, thinking they're going to find the remains. Oh my gosh, here it comes. And then there was nothing there. So, yeah. Flossie's Fibbery. Prosecutor has egg all over her narcissistic face. You can't. Yes, we can blame the prosecutors. Understand we'll be applying for a job. Let's see here. I got another super chat here. Scott, could the judge dismiss without prejudice because the public interest outweighs the prosecution's blunders? Well, what the court has to decide is this motion made in good faith? Now, that's going to be the big issue for the court to decide. Am I going to allow them to dismiss this case so close to a trial date? It's supposed to start in 9 days. Jury selection was supposed to start in 9 days. Speedy trial is running. The prosecution is clearly not ready. They did not have the evidence to convict. And now they're coming up with some sort of an excuse to say, Judge, trust me. Okay? Where Linda Stanley's office, I'm not sure you can, based upon the motions, and I'm telling you, I have never, ever, ever seen a judge blast a district attorney's office for discovery violations like that. Never. Okay? That means it was so outrageous and egregious, and it wasn't just a one-time, in good faith, we thought that we had turned all this information over. When it turned out that not only had they not, but they had represented that they had, and they had not. So I don't think their office is particularly high on the integrity scale when it comes to the court. So I think the court is going to say, yeah, I don't know. Like I said, my first question would be, okay, you think you have a location where you can locate the remains of Suzanne Morphew. When did you discover this information? And why is this different than back in May of 2021 when you filed charges, right? Because it's the prosecution's duty. And this is what I'm trying to get, ladies and gentlemen. This is the kind of thing that should offend everybody. Whether you are a prosecutor, you are a victim advocate in all regards, this is offensive. The prosecutors have so much power to ruin one's name and reputation, arrest somebody, completely turn their world upside down, and through their own incompetence, they basically say, oh, yeah, we're not ready to go, Judge. Give us one more bite at the apple. Trust me. I don't know what the judge is ultimately going to do, but if it were me, I'd say no. Motion to dismiss denied. See you here on April 28th. We're going to start jury selection. You guys are going forward. The law is such that, they're making their statement, but I don't think they're going to get another bite. I don't think they should get another bite at the apple. That's what I'm thinking. That's really what it boils down to in my position, my thinking. Daddy's Girl, $20 super chat. Thank you very much. Scott, I hope you have a very happy Easter. Thank you. It was a nice Easter, that's for sure. Scott, should they have to pay his bill? Well, there's nothing in the provision, nothing in the law that says, and that's also another thing. I mean, if the prosecution charges you, they have immunity, right? Unless you can show bad faith, which Barry Morphew is suing them all. And, he may get a check from them. But unfortunately, no, the prosecution does not pay the legal fees. And I'm telling you, those fees are going to be expensive. And that's the thing that just is outrageous to me is the fact that we're not talking about a little misdemeanor case. Oh, we can't prove your speeding ticket. They charged this man with first-degree murder. Okay? And here they are on the eve of his trial. And all of a sudden, we're going to dismiss Judge. Not a single mention about their incompetence in here when it comes to good faith. Oh, we think we're getting close to finding the body? Really? What made you think that this was it all of a sudden? So I just think that it is a situation where the prosecution, they shouldn't get a chance to benefit from their incompetence. And that is what it is absolute incompetence. So I just, what can I say? Let's see. Why hasn't Suzanne's brother said anything? He was very vocal to start with. I don't know. Scott, you give high blood pressure. Barry did it. Barry did it. Barry did it. Barry did it. Well, Helena, he hasn't been convicted of anything because we give everyone the presumption of innocence here. Okay. Let's see here. Yeah, Becca Stanley filed this motion at 8:51, 9 minutes before the motion hearing was set to begin. Let's see here. Devon Nelson. Dang, Scott. Oh, Frank's sending me something here real quick. Dang, Scott, you said all along that this case would wind up getting dismissed. I did. I'd say it, but it did. I haven't called it yesterday. Remember way back when, and there was that Chris Watts thing, and they set the case for a disposition, or they set it for a date, and I'm like, well, something's going to happen. I said he's probably going to plead guilty because they just don't, if they're going to continue it, they can set it off record, all that kind of good stuff. But so yeah, bottom line is, called it. And I'm not saying I get it right all the time, but I'm saying I usually can kind of tell how these things are going to go. And but hopefully that's why you come here to get a real analysis of the law with the facts, and versus just let me take a quick look here. Looks like breaking news. Did the judge actually sign it? In a surprise turn, it was the prosecution who filed the motion to dismiss. No, it wasn't. They're the only ones that can truly file that. I mean, yes, you can file a motion to dismiss, but the judge doesn't have a whole lot of authority unless they can show bad faith. And, the judge said you're getting real close to it, but let's see. However, it doesn't necessarily end the thing. Dismissal without prejudice means, these people don't know what they're talking about. They're cutting and pasting. They don't know what it means. I appreciate you sending me that link, Frank, but it's still not.
He says he's working as a free man.
Yeah, he is a free man. I mean, it says the judge dismisses the case, but I don't see a signed order here from the judge just yet, or if there was any objection from the defense. But yeah, it's not surprising. I thought it may have been coming as early as last night. So yeah. Yeah, you got it right again. Let's see here. Look at these couple of questions. If you got any questions, yeah. Now, the person that needs to come on and explain, Robin Wolf, is that an elected office for the DA? Yes, she's an elected official. And their main number to the DA's office is 719-269-0170. So if you want to let your frustrations be known to Linda Stanley, that is their main reception office. And you can certainly contact your public official at that number. Yep. Okay, they're saying he left the courthouse as a free man after judge agreed to dismiss the case. Remember, Ali 79, remember when Linda Stanley answered a question of if there is no body, how can she prosecute? She said, it's my job to worry about that. Well, looks like she put the cart before the bobcat. Just, ladies and gentlemen, yes, you can do a case. Is it impossible to prosecute a homicide case without a body? No. However, you still have to prove that someone is actually deceased. That in and of itself could raise reasonable doubt. And then you still have to be able to show that the defendant, not someone that looked like him, not someone using his identity, but it was in fact him and not some other guy or somebody with some other's DNA that may have had something to do with it. So congratulations to Barry Morphew's legal team. They did their job. They held the government to their burden of proof of beyond a reasonable doubt, and the government failed miserably. And I don't want to beat a dead horse here. I'm sure Linda Stanley's probably beaten herself up bad enough. But the reality of it is that if you want somebody to blame about Barry Morphew walking out of that courthouse, a free man, you have no one to blame but Linda Stanley. She's the one that submitted the affidavit, charged him, took all the glory for arresting him, tried to keep somebody in custody when there wasn't sufficient evidence to do so, and then, bam, they're the ones that screw the case up because they ignored the court's orders. Bree wants to know, okay, so the judge may have given him more time. I'm telling you, this, ladies and gentlemen, this 10 pages of saying that we're dismissing without prejudice because we're really hunting down. We're really going to track down this body. We're going to make sure. Ladies and gentlemen, this is the DA trying to save face, okay? All they had to do is say, Your Honor, based upon the court's rulings, the way the standing of the evidence, the people moved to dismiss the case. That's all they had to say. And 10 pages of trying to say why, Judge, trust us. Yes, we haven't been completely honest and expressed complete candor to the court, but trust us this time. Short of a confession or locating the remains with a note that says, somebody signed their name and said, I did it, put it here, put the body there. They're not going to find anything, ladies and gentlemen. This case is over. Stacy B. Yeah, the prosecution sucks. I don't think there's any way around it. They blew it, man. And they brought in DAs. They hired former DAs. They brought in all kinds of people. And anyone with any experience, they ran from that case. They looked at what a cluster blank, you can fill it in, what a cluster that office had created. And I think, let's just face it, they just don't prosecute that many homicide cases. Yes, one can say a homicide case is basically it's an assault gone bad, but there's huge consequences to it, and people fight those cases, and it just wasn't there. It just wasn't there. So, case dismissed. Let's see. Rhonda Blackburn, he will blow his or Suzanne's cash on himself and his daughters, and he will be unable to afford the dream team. Yeah, but Rhonda, this case is not coming back. Okay, this case is not coming back. Candy Corn 68, did the judge throw the case out? No, the prosecution filed a motion to dismiss. Okay. And they completely tried to avoid the fact that we can't prove our case beyond a reasonable doubt. And trial is supposed to start in 9 days for jury selection. They basically came up with, we can't prove this case beyond a reasonable doubt, but Judge, we really think we're getting close to finding a body that, we're not, so trust us, we're going to do it. No, this is face saving. This case is done. There is not going to be any future cases. What has he got? They dismissed the case. I think was there another case? The voting thing was like a forgery or something. That was a separate case, I think, right? So I guess he still has to deal with that. We'll see if they dismiss that case as well. Where they got the misdemeanor one where he voted for Suzanne. That's the allegation there. Yeah. Jeanette MCG. Maybe the DA watched too many true crime podcasts about this. Maybe beforehand or after. I don't know. If she had come here, we would have told her pretty weak case for sure. Phoenix with love. Yes, Patrick Frazee had his crazy girlfriend clean that up for him. That's why he was caught. That's correct. The civil case, yes, I agree. Jen Madison would be interesting. Would it be a defamation case, or is there a filing yet for the civil case? They already filed the civil case against basically everybody, saying that they violated his constitutional rights because they recklessly withheld evidence from the, from the defense. Yeah. Let's see. I've noticed the prosecutions are very dirty in some cases. She was blowhard from the gate. They said the families are in agreement with the decision. Yeah, because the sister, let's just read it so we don't, we want to make sure we get it accurate. This is from page 10 of the district attorney's victims' rights contact, right? Because it's a victim rights case. They have to do that. The people spoke with Melinda Mormon Baum Monk, the victim's sister and primary representative for the Mormon family. Miss Mormon Ma Monk relayed her agreement with the motion to dismiss and expressed her wishes that we ultimately resolve absolutely whether or not her sister is dead prior to further prosecution. Like, if that doesn't scream of reasonable doubt when the victim's sister thinks there's doubt as to whether she may even be deceased, like, what the hell was the DA thinking taking this case? I don't know. Let's see here. Has the judge... Okay, yeah, the judge dismissed the case. Hey, doesn't Lori Vallow have a court appearance today? Yes, 9 o'clock was the motions hearing for Barry Morphew. 1:30 Mountain Time there in Idaho is the arraignment for Lori Vallow. Unfortunately, it won't be live. They can take video, but it can't be live streamed. But we'll be monitoring that in case something shows up on their page, so to speak. Yes, he has left the courthouse. Hempland, Texas. The other DNA was completely ruled out by the prosecution. That's what they say. I'm not convinced about that. It came up in a CODIS hit, so there was enough DNA sample to come up with a CODIS hit. So, yeah, it was there. It's exculpatory. Sumting Wong, SUMTINGWONG. Why has Linda Stanley been absent from the courtroom so much during the last 6 months? Too confident, too embarrassed, too self-aware? If I was a betting man, I was thinking that she was hoping that she did not have to answer the questions to the court as to why there were so many delays. I mean, normally the DA, the elected DA, would stand up and say, we're going to go forward with this case. Now, I'm just looking at her bar number here, and her bar number is half, so she has probably been practicing law 15 years maybe, it looks like. And she's been primarily, I don't know her, I don't think I've ever had a case with her, at least not to my memory. But if she's, practicing predominantly smaller jurisdictions, you don't get to do that many homicide cases. So, yeah. Let's see. Stace on the case. Can't allow prosecutors to go rogue. No. I mean, the defense did a brilliant job. And like I said, the defense did their job. The defense attorneys did their job. The people that should, if somebody is upset and they do not like this result, blame the DA. The DA screwed this case up so bad. That's just the way it is. Man, these things are going by so fast. Ruby's that they screwed it up so bad. Let me see if this is... Scott, off topic again. Sorry. What about murder with malice, first-degree murder, kidnapping, stalking? I mean, the malice definition in most jurisdictions is you do it with a forethought and malice, basically an evil heart. It's just kind of an element that goes to the after deliberation part. Hopefully that answers the question. There's the other one. Oh, you are the undisputed king of true crime on YouTube and beyond. Grandmaster Sid Sophos? Well, thanks. Oh my, save that. I like that. The undisputed king of true crime. That's right. We are talking about cases with half our brain tied behind our back just to make it fair for all of these other commentators that, and listen, we love all of our fellow YouTubers, okay? We do. We love them all. But I was getting so many people saying, Scott, what are you doing? You're just some hack, defense attorney. It's, whatever, blah, blah, blah. And they were coming up with all these different theories and trying to... I get it. They got to come up with something to create content. But ladies and gentlemen, like we try to deal with here, we'd like to deal with facts and the law. That's what we try to stick to. Speculation, it's not admissible in court. It's not admissible in court. So you try not to speculate too much. And don't get me wrong. I mean, I love to gossip just as much as anybody else, so to speak. But, the bottom line is they can't do it. Jen Madison, did they overcharge on purpose? No, I think they truly thought that he did it. But I've said this before, and, listen, it doesn't matter what you think. It only matters what you can prove with legally competent and legally admissible evidence. That's it. That's the only thing that matters in a court of law. And that's why people are like, oh, Scott, you're insensitive. Oh, Scott, how could you say that? How can you're just, you don't have any empathy or sympathy for it. I do. If he had... if the prosecution had been able to prove their case against Barry Morphew, so be it. I don't have any dog in that fight. But I just saw that it was a flawed case from the beginning. I called it that way. And even as recently as yesterday, I thought, man, maybe if the DAs are going to dismiss, they're going to do it today at the trial readiness conference. Because guess what? They were going to bring those jurors in, and they didn't want to disrupt all those jurors' lives. So, bottom line, that's it. But Grandmaster Sid, best comment of the day. You're the undisputed king of true crime on YouTube and beyond. Thank you. I love that. I'm gonna get a T-shirt made. You're the undisputed king of true crime. I love that. Thank you, Sid. Now, it looks like it shows up in pounds. So is Grandmaster Sid, he must be out of the country. Julie, will you reach out to Grandmaster Sid? Because he does. Yeah. Grandmaster Sid, can you reach out to Julie? And we're going to send you a T-shirt of your choice because, seriously, I love that. The Undisputed King. I love that. There you go. This case is not coming back. Scott Reich, April 19th, 2022. Scott said it. It's gone. It's done. Okay? Let's see. God forbid journalists trying to tell the truth. That woman was blaming Lauren was disgusting. Ms. Johnson. So if they find her body, can they prosecute him? Well, it depends. Basically, what that says is that if they find the body, they can obviously now prove that she is deceased, correct? But And what's the word I'm looking for? But they still have to prove that Barry Morphew did it. Okay? That's what they have to prove. That's why identity is so important. That's one of the things that they have to prove in every criminal case, that it was the defendant. A dead body does not mean that somebody, they have to be able to prove who did it. Bottom line. So maybe if they found a body, okay, but listen, color me skeptical as to how they are just now happen to find this no location where they think that the body's been located. Color me skeptical. Color me skeptical. They're not going to find anything. And if this was such great hot news, they would be digging up there right now. And when did they find out about it? Why haven't they been there all of last year? They filed in on this case in May 6th of 2021. Where were you doing in June, July, August, September, October when there was no snow up there? Cole, you may be wrong about Lori Vallow and her competency, so maybe you can be wrong again, perhaps. But I was kind of partly wrong. I didn't think they were going to restore her, but then somebody reminded me on our Patreon show that, Scott, you said that they were just going to dope her up and get her back to competency. I was like, be patient, she'll be back. So I was half wrong. We actually have that video. I think that was a couple nights ago. They need to shut down and search every landfill, which would be the 5 trash bags they believe dumped. Yeah. Yes, there is no statute of limitations for prosecution of a homicide case, first-degree murder anyway. Bottom line is, the reality of it is that the prosecution would have to show that they had this new evidence and it wasn't delayed. If they attempted to refile this, the defense would argue bad faith, that they were just, my bet, say it today, this case is done. Barry Morphew is not going to be prosecuted ever again for the death of Suzanne Morphew. Just what I'm saying. Terry, Barry will be in Morphew for Mexico for dinner tonight, but I think he's got that little misdemeanor case, so he's probably going to have to get permission to travel. The prosecutors ruled out the DNA in her car already. Yeah, that's what they keep saying. The defense didn't rule that out. And guess what? The judge didn't either, because he kept saying it's exculpatory. So, I don't know how you can rule out somebody else's DNA as somebody is in the car. There was somebody else's DNA that was linked to 3 other CODIS hits in 3 other states or 2 other states. So that's exculpatory. That goes because there's no deceased, there's no body, ladies and gentlemen. The prosecution just, I literally, I can't believe they brought this case. I really cannot. I said it way back when. I thought it was weak. But hey, all it takes is an allegation to get charged. The prosecution made the allegation. They were unable to do this. If somebody wanted to express their frustration with Linda Stanley, a public official at her public office, 719-269-0170, you can let them know that you're not happy with a public official who completely botched this case from the beginning. Something wrong. Something tells me that Barry and his defense will make the team and the agents more embarrassed. Oh, it's coming. It's coming. It is coming. I picked a bad time to be late. Let's see here. He'll move to another country with no extradition. Maybe. Who knows? Listen, I'm not sure how much money he's going to have left. I don't know what his financial situation was. He, I think, sold his house, sold the other house, had $500,000 that he posted for a cash bond. So he's got $500,000. My guess is a good chunk of that's probably going to go to the attorneys. Just guessing. Good, They spent a lot of time, energy, and money on this case. Yeah. So let's see. It's gonna read a couple more comments here today. I love that. Grandmaster Sid, you're the undisputed king of true crime. I love that. Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich, the undisputed king of true crime, according to Grandmaster Sid. I love that. Grandmaster Sid, I do not think it's a horrible outcome. Worse thing could have been going to jail. Who is innocent? Second, there could be another predator out there. Michelle, not necessarily wrong. The thing is, he will always live with the fear he'll be rearrested. As adults, we know how something as big as murder will hang over you in your dreams. He's been... Yeah, we're not even going to go there. Nancy Eileen, so no coming back unless a body found. Even if a body was found, bottom line is you still got to prove he did it. I mean, their rationale in this motion, okay? They give the background in this motion to dismiss, and, here's the case. And then they say, hey, the prosecution has the constitutional power to exercise in its discretion in deciding several possible outcomes to pursue in a criminal case. And then they cite some case law. It says that common law, the prosecution has a unilateral authority to dismiss criminal charges through the entry of a no pros. The authority was limited by the enactment of Criminal Rule 48, which basically says you have to be able to state in open court, why are you not being able to go forward and prosecute this case? And it says the decision to request a dismissal of pending criminal charges is within the district attorney's discretion, and this decision may not be controlled or limited by judicial intervention. The trial court, however, should not arbitrarily substitute its own decision for that of the prosecution. Rather, the court must exercise judicial restraint and only act if the dismissal is clearly contrary to public interest. A trial court's refusal to consent to dismissal of charges is only appropriate where the evidence is clear and convincing that the interests of the defendant or the public are jeopardized by the refusal to prosecute. Then they go on on page 5. Similarly, the prosecution pointed they had. This is talking about other cases, but they're trying to rationalize it here. But they go on. It says the court held that the discretion lies with the prosecution. And then it says the effect or dismissal with prejudice or no pros has varied. It says the dismissal has varied effects with regard to the final disposition of a case. In some instances, a dismissal will preclude further prosecution, and in others, it will not. A dismissal without prejudice or nolo prosequi is a formal declaration of record by the prosecutor that the government will not prosecute the case further. It is a discharge without an acquittal and is not a bar to subsequent prosecution for the same crime. A nolo prosequi, no pros, order is not the final disposition of a criminal case, but leaves the matter in the same condition as the charges were filed. Thus, the indictment against the defendant would function as a nullity upon its dismissal without prejudice. And they go on, the Colorado rule mirrors the federal rules. The dismissal properly takes under Federal Rule 48 is without prejudice, and with the period of statute of limitations, a second indictment or information may be brought against the same charges. Yet they're not going to do that, ladies and gentlemen. And then this is the part that I think is interesting. Argument, page 7. A good faith basis to dismiss. As an offer of proof, the people and law enforcement believe we are close to discovering the victim's body. The people are hopeful that the search for and the discovery of the victim's body would be concluded well before trial. But weather has complicated these efforts. Specifically, the law enforcement has been focused is in a remote and mountainous region, thereby the Morphew residents. The area received a significant amount of snow over the winter months before a search could be completed. To date, the area has 5 feet of snow concealing the location where the people believe Mr. Morphew is located. As a result, the people cannot safely excavate this area and resolve this unanswered question. By filing this motion, the people have complied with Rule 38, motion dismissed, submitted in writing, publicly available, proffered in open court, and accompanied by a statement summarizing the reasons for the actions. Given the timing of the motion before trial, the defense does not need to consent and does not have standing to object. Basically, it doesn't matter what the defense wants. The court need only resolve the question of whether or not this motion was filed in good faith, such that clear and convincing reasons exist which further the interests of justice for the public and the defendant. Issues related to speedy trial or any other outstanding litigation would not be relevant to the court's determination at this juncture. But yet there's no case law supporting that particular proffer that the prosecution is making. And they say they're going, once again, they have the people's fundamental responsibility in the criminal justice system is not to gain a conviction, but to further the truth-seeking process and ensure equal justice. In typical homicide cases, the fact of the victim's death is rarely at issue. But in a case such as this, the most influential fact of consequence is whether or not Miss Morphew is deceased. If the body proves to be there, further forensic examinations could potentially inculpate or exculpate the defendant, which is incredibly important evidence for the jury to hear in determining the merits of the case. Given the need to conduct further investigation to resolve these issues, this is a good faith basis for dismissing the case. Wow, that's almost like something they should have said back in May of 2021 when they didn't file charges and say, we don't have a body yet. It's going to be difficult to prove this case. And then they go on and say, second, when this case was filed, it was mainly premised on the defendant's motive to harm the victim. His sole access to the victim and the exact time she was last communicating with anyone by phone, and his consistent dishonesty with law enforcement, which came to light given the truck telematics, phone, and location data recovered, all of which was not coming into evidence, the court functionally excluded the people's best evidence to move forward in this case by severely limiting our expert testimony. Even if the court were to partially reconsider its position on the need for such severe sanctions at this late hour, the people would still be left without several key expert witnesses initially endorsed. Without this crucial evidence and without the victim's body, the people cannot move forward at this time in good faith. Ethics demand that prosecutors proceed to trial only in circumstances where a reasonable likelihood of success exists, which, given the court's current ruling and the uncertainty of any further rulings, is possible to completely ascertain. This assessment of the remaining evidence, in additional good faith basis for this motion dismissed without prejudice. Wow. Wow. Why didn't they just say that early on? That's why they should not have proven this case or even filed this case. This is why they should not have filed this case, is they didn't have a body, and their job is to engage in the truth-seeking process and to ensure equal justice. And they acknowledge that it's rare to not have a body. And then they go on to say that they basically cannot proceed in light of the court's rulings. So they can't prove this case beyond a reasonable doubt. I think they would have a very, very difficult time coming forward unless there is some new and independent evidence that wasn't available at this time. Yeah. What can I say? What can I say? All right, ladies and gentlemen, that's I can't believe I skipped over those two paragraphs. Those are probably the two most damning paragraphs of that entire motion that they filed. All that ethical stuff that they should have been considering and telling everybody about a year ago didn't matter. Nope, didn't matter. Didn't matter a year ago. Now all of a sudden it's really important when they can't prove their case. And oh, by the way, Judge, it's your fault for gutting our case, but you failed to mention in your motion to dismiss that it was your fault, Linda Stanley, for everything that took place. Wow. Will they follow Barry now? Yes, they can, but he's represented, so they'll never be able to interview him again without his attorney being present, which will never take place. So, You remember some of the evidence in the case was that they basically befriended Barry. Hey, come on over for dinner, man. Yeah. And just getting him to talk, hoping he was going to say something, you know. So yeah, let's see a couple questions here, and then I think we're going to call it. Now I think he's moving, Mama Pink. Remember he was moving out of town right before he got busted. I think he's still got one more case to resolve. I think it was a misdemeanor case or some other case. There was something small where it was like, you know, he filled out her ballot. Remember, she'd filled out the ballot, and his comment was, "Well, yeah, she would have wanted to vote for Trump, so I did it for her." Remember that? That was. Yeah, I mean, I'd have to go back and look because he had a couple of other charges, some minor things. Let's see here, a couple more questions if we got Anne-Marie Marino, watch out, Colorado wives, don't piss off your husbands. Well, I don't think it's that bad yet. Although you may have to wonder if maybe there's something in the water here. I don't get it. Be sure to hit that. Yes. K Black, OFS, comma, FFS. They had 2 years and plenty of opportunity to get the body. It's gone. Jojo Cannon, wow, how the wealthy get away with everything. Jojo, he had a good defense, right? I'm not going to say that. Money helps. I'm not going to deny it. Hopefully the public defenders would have done just as good as job for him. But the reality of it is, like I said, you don't like this decision. The 11th Judicial District, the elected district attorney, Linda Stanley. It's not like we're giving somebody's home address here. This is her work number. A public official, 719-269-0170. Okay? You can let them know that, man, we think that you completely trashed this case. Bottom line. But, just think, if you want to start something, I think they were trying to force him to plead, and it didn't work. Of course they were. Kate does crime. The prosecution is always trying to get somebody to plead guilty, okay? And they oftentimes will overcharge a case, thinking, oh my gosh, I can't risk, that penalty of the most severe charge, even though the prosecutor knows that they can't prove that case, but they still do that, and they get you to try to, plead guilty. They do that all the time. I think it's, you really didn't even have plea bargains. Most people know this. You didn't really have plea bargaining until the early 70s. It used to be if you charged it, you got to plead guilty to the most serious offense. There was none of this charge bargaining stuff. If the prosecutors thought you did it, they should be able to prove it. It's interesting how that all developed. Basically, when they kind of began the war on drugs, so to speak, they kind of started. The courts couldn't handle the system, so they're like, we got a plea bargain. Otherwise, it'll completely shut the system down. It used to be you only pled guilty when you were actually guilty of something. None of this Alford plea stuff. But then the Supreme Court said we can do it because they knew they were going to shut the system down. Just saying. Susan Batterman, looks like there will be no justice for poor Suzanne. May she haunt Barry the rest of her days. I understand, but he's got to be given the presumption of innocence. And, the bottom line is blame Linda Stanley, the elected DA. Her office completely gutted this case, screwed it up from the beginning. And I know I was the odd man out throughout this entire process. Everybody's, oh, Scott, he did it. Look at all the theories. Oh, my gosh, blah, blah. Only matters what the government can prove. It only matters what they can prove by legal and competent evidence, which is it admissible pursuant to the rules of evidence. Sandy F., couldn't the defense say the prosecution pays legal fees? No, but there's a civil case where he filed a case basically saying his civil rights were violated, and in that case, the good people of Chaffee County there could in fact wind up paying his legal fees in a thing called damages. And, they changed the law here. Public officials and law enforcement don't have basically qualified immunity, like, oh, whatever you do, it doesn't really affect me. Now you can you can get up to, I think, $25,000 from the individual police officers. So they can collect individually up to $25,000 under the new law here. So, yeah. And, this is like one of those cases where it's a close call. Was the guy resisting arrest, or was the cop being a complete jerk? Well, the prosecution absolutely wants a conviction, because then they can't go sue saying, oh, you did it, right? This is that case. I'm sure all those officers that are being sued, Linda Stanley, I believe, is being sued individually as well. The pucker factor right now just went up tenfold for them, because now his plaintiff attorneys are going to be like, we're coming for you. And suddenly the hunters become the hunted. Ooh, it's not going to be good. Yeah. Let's see here. A couple more questions. Scott, how much resources will they put in to continue the investigation where there's a good chance they can't prosecute? Little to none. If they, seriously, I would be up there. Spring is coming. They say there's 5 feet of snow up there. Where they think this location is. Color me skeptical. Basically what I'm saying is the DA was looking for some reason to say why the court should dismiss this case and allow them to refile if they file anything. But the other 2 paragraphs that I read, which was basically, we can't prove this case beyond a reasonable doubt because we have no body, and also that we don't have the evidence to go forward. The whole thing about digging up a body somewhere, that's just puffery. There's nothing going to happen to that. Let's see here. Honey Bear says, I'm not 100% convinced she didn't run away. I've seen the garbage dumps, but you'd think if he was throwing away parts of her, surely some of her blood would seep through the bags. It's not a strong case, ladies and gentlemen. It never was. Probably never should have been filed one way or the other. And it's not because he had a few bucks in his pocket. I assure you, he has a lot less resources today, okay? And I'm sure he owes even more. But whatever his attorney's final bill is, he should pay it and say thank you very much. They did their jobs. They did the job that was basically their legal and ethical obligation, which is to hold the government to a standard of proof beyond a reasonable doubt, which is that legal standard. And the prosecution failed. I'm telling you, this is not Barry Morphew's getting away with something. This is not the attorneys being too aggressive. This is all on Linda Stanley, and if that's all it is. And Jen Lowe, I agree. They will find nothing. That's right. All right, well, that's the breaking news. Hope you enjoyed it. I think that's really all there is to say. We'll probably have a little bit more in a quick Today show. And hey, don't forget to join us tonight for our live 6 p.m. Mountain Time. We'll have some updated information on Lori Vallow and Chad Daybell and how those hearings went today. We'll see. We'll see how everything's going to go. And so thanks for watching the undisputed king of true crime, according to one of our subscribers, viewers there. Because, hey, what can I say? We called it. Called it yesterday. If they were going to file a motion to dismiss, it would be here today. Called it. Called it. Called it. That's right. You can go talk and listen to all those other little people that do the true crime, talk about all their crazy theories. When you want some real answers, some real analysis, come here to CrimeTalk, okay? Thanks for watching. I appreciate you all. I do. Thanks for being here. We'll see you later today, and don't forget to join us for our live show at 6 p.m. Mountain Time. Think we have a little bit to talk about? I'm sure we'll talk about Barry Morphew, and we'll talk about Lori Vallow and Chad Daybell. Have a wonderful day. We'll see you later tonight.